Yes.
Please, my lords, just before coming back to Draxelmeier, can I just say something about the chronology, which I should have done when I started? If my lords would go to tab 7 of the core bundle. And the fourth bullet point of tab 7 recites 17th, 18th March, Novartis application PI heard by Mr. Justice Roth. At the end of the hearing, the first, the third, and fifth defence gave undertaking not to supply fingolimod. That was supported by a cross-undertaking in the usual way.
Yeah.
Also, the second open bullet point under the next entry of 26th of April, Mr. Justice Roth's order confirmed that for the avoidance of doubt, this would not prevent the defendants from participating in tender processes being run by NHS England and not NHS Wales. The reason predominantly that was no PI was granted in this case was because all the sales are effectively made on tender, and therefore damages are a much more quantifiable thing, and therefore they could be quantified if the defendants went ahead. But in fact, there were very few tender dates in these periods anyway, except go down to 1st of May, proposed contract start date for NHS England tender for fingolimod. Teva, Dr. Reddy's, Zentiva and Viatris placed successful bids in that tender. So they went ahead and got the tenders, and the cross-undertaking is obviously open to the defendants, but in fact it may not be that significant because of the way tenders operate. But the fact of the matter is, in principle, the claim is open to all defendants and the NHS, and indeed I understand at least one has made some claim on it, but we don't deny that the entitlement is there. Can I then go back to the Draxelmeier case, which is at tab 15 of the Joint Authorities bundle? And this is a case that Council were rightly asked to look at by Lord Justice Arnold. It is pertinent. It's a truly remarkable case on the facts, which would be hard to make up. As Sir Anthony Mann said in paragraph 4, impossible to admire, is the way he put it. The claimant, as the applicant for a declaration of non-infringement, even went to the lengths of restoring the patentee's patent so it could maintain its claim for a DNI, even though the patentee thought it had lapsed. So that gives an indication of how strange it was. But in the end, the deal was done with Mercedes-Benz in Germany, which meant that the point became academic even in Germany. It was common ground. This is paragraph 27. The point was academic, at least by that time. And in fact, the judge went on to hold actually it was academic from the outset, or shouldn't have been brought. But come to that in a minute. But the fact of the matter is, once there was a deal in Germany, even if there ever had been a point to the action, that disappeared, and the only question was whether the action should be struck out or just stayed generally. And as often is the case, the real argument was about costs. And the question was whether the action was ever proper, went to the question of costs, which is what it was all about at the end of the day. If the court would go to the findings on page 406, paragraph 32, where he recites the main factual matter underlying the current dispute is what the purpose of these proceedings is, and what the motivation of Draxelmeier was for bringing and maintaining them. I consider there's no doubt the predominant motive by a long way in their bringing the present proceedings was to obtain a DNI for the purpose of being able to place it before the German infringement court to show the views of the English court on infringement. And he discusses that, but the finding is at the end of 34, and he says, I therefore find, last 5 lines, that the vastly predominant motive in bringing and maintaining the DNA claim was to produce a judgment on infringement deployment at the German court. Any technical residual expressed intention to do an infringing act is almost de minimis in this context. Then if the court would go to paragraph 47, what the judge does is the judge from 36 onwards addresses the case law on abuse of process, that's paragraph 36 and following, and he comes to paragraph 47, to the finding, which is important. He says, there is therefore no reason why the abuse jurisdiction should not be applied to an action brought under section 71, and that allows in considerations of useful purpose or its absence, and if appropriate, an illegitimate collateral purpose. And section 71 is a statutory declaratory provision, whereby the court can declare that you don't infringe another person's patent. So he's basically saying the common law on declarations applies to the statutory declaration under the Act as well. And he says in 48, the most material form of abuse are lack of useful purpose, aversion of Jamil, and pursuing them for collateral purposes. On the facts of this case, they effectively intertwine, and he discusses Jamil from paragraph 49 onwards, and then he discusses at which points the offer of protection being offered became pointless at 51, 52. And he says the pointlessness, in 51, the pointlessness aspect of the abuse didn't exist at that time. The odd act on the part of Draxelmeier paying for the restoration doesn't go to this aspect of the abuse. That remained the position in April 82. And then he says, the last 4 lines, the position, and this is on uselessness, was reinforced even more when the undertaking was given. At that point, the proceedings were apparently pointless in terms of the value of the remedy, unless something unconventional was also operating. So it became increasingly pointless. He discusses the authorities on abuse in this context in paragraph 54 onwards. And one of the points that was being run was the use in Germany, or putative use in Germany, obviously. And if the court would go to 57 on page 413, I should deal with the evidence such as it is as to whether or not the German court would itself pay any attention to a decision of this court on infringement. Putting it briefly, each side has put in evidence supporting its case. Draxelmeier has put in evidence saying the German court would pay some attention to it. Boss has said it would not. I can't resolve that difference. I'll leave it as a matter in dispute. So he's prepared to accept one way or the other that it might be of some use, but he wasn't going to resolve it. He says the first relevant authority is the decision of Mr. Justice Arnold and TNS and Nielsen. This, like most other cases, is one involving validity. The case was one in which there was an application to strike out a claim challenging validity on Jamil basis on the footing the patentee had offered a license, which was said to remove any commercial need to challenge the patent. There was also an additional commercial need based on the interaction between the expiry of the patent and preceding a new contract, which would presumably otherwise have been relevant, paragraph 5. Mr. Justice Arnold accepted that the claim could be struck out, but it was pointless and wasteful, but that didn't apply to a case such as that before him. He declined to strike out the claim, following other cases which refused to strike out validity challenges on the footing that Section 70 of the Act permitted any person to challenge a patent. Then, at 59, Mr. Justice Arnold turned to the question of collateral purpose. The evidence of the patentee was that it wished to have an English revocation to show potential customers in other jurisdictions where there was an equivalent EU patent, those other patents were worthless. Such a decision may be exported to the national courts or shown to customers or potential customers. And my Lord Mr. Justice Arnold cited other authority, which is quoted by Sir Anthony Mann. He says at 60, they all involve validity challenges. And at 61, he comes to visit Fujifilm and the quotation from IPCOM of my Lord Justice Floyd, which we've seen already this morning. And then he comes to paragraph 62, Mr. Justice Henry Carr's considering value of spin-off, which we also looked at, except the spin-off can be very valuable and so on, we've seen that. He says the qualifications in that paragraph are of significance in this case. The present proceedings are not really brought because there's a real connection with this jurisdiction, despite the terms of the D&I notice. They are in substance brought in order to achieve some sort of influence in the German court. He then refers back to Mr. Justice Henry Carr in 377, which we say is correct. My then friend says it's wrong. This is whether he's concerned with whether it will serve a useful purpose in the United Kingdom. And then he goes on to refer to the fact that Mr. Justice Henry Carr did not consider it worth relying upon those, but he turned to spin-off value and doesn't rely upon it. And 65 is important. What the judge did not want to do was to analyse the circumstances in which an English judgment would be used for in other jurisdictions, but paragraph 411 would seem to indicate that he had the injunction gap in mind. Mr. Justice Meller accepted that relevance in his judgment in this case. That's different from the use to which Draxelmeier would wish to put an English judgment in this case. It would also appear that Mr. Justice Henry Carr was very cautious about allowing claims with no real connection in this jurisdiction. That's apparent from what he said, and with his citation of Lord Justice Floyd to the same effect, with apparent approval, I would respectfully agree. So there's, again, another judicial approval of that line of thinking. It's right to point out what the same judge said in Takeda and Hoffman and Roche, and I'm going to come back to Takeda because the judge didn't know what subsequently happened in Takeda, and I'll come back to that if I may. As in all, 67, as in all other old authorities which bear on this point, that case involved a substantive action in this jurisdiction, which would have been run even if the question of use of the judgment for it had not arisen. That seems to me to be a material consideration and ultimately a distinction. He then comes on to the cases of Fresenius and Carefuge and Mr. Justice Voss. Now, Knowles may be familiar with the fact that that was the case that put an end to the Earth Closet Order. And what had happened was that an Earth Closet Order had been given, and what had then happened is that there had been revocation of the action in the light of the newly pleaded prior art, which was a Japanese patent.
I'm not sure all members of the court will be familiar with the Earth Closet Order, Mr. Moore.
No. Indeed, but it was an old procedure whereby if you turned up a subject to a new piece of prior art, basically, as a patentee, you could offer to jack your case in and get all your costs, which was considered to be a bit harsh, because it didn't really investigate the circumstances in which the new prior art was being deployed. It was almost routine, and not thought to be a good thing, in another case called Williamson and Moldline. Anyway, in Fresenius and Carefusion, what had happened was that there had been a submission to revocation. And then along had come this death of the Earth Closet Order, and the question was what should happen. And that sort of sums up the first part of 68. Mr. Justice Voss had to consider whether to order a trial to consider the basis on which a patent failed in circumstances in which the patentee agreed the patent should be revoked, which is apparently the subject of the action, but did not agree the grounds for revocation. So the patentee was not prepared to say, I'm prepared to agree it was revoked on the basis of the new piece of Japanese prior art. The challenger to the patent sought a trial to establish those grounds, and it seems to have relied upon being able to use such matters in a foreign jurisdiction. So it's being said, look, it would be useful for me to have a judgment saying it's obvious over the Japanese prior art because I want to use it in other jurisdictions. Mr. Justice Voss considered TNS and Mr. Justice Arnold. All Mr. Justice Arnold was saying there was that if the underlying reason for litigation which is contested is that the claimants wish to establish something which can be used in a foreign jurisdiction in a patent context, that is not a good reason for saying the proceedings are an abusive process. I respectfully agree. Yet Mr. Justice Voss refused to allow the case to go on. He said that the successful party got what it wanted, the patent was revoked, there was no point in disputing the details. He went on, I reached this conclusion without any regret. It seems to me it's not appropriate for the court to try academic questions which may be of interest in other jurisdictions. And we say that that is respectfully correct. This applies as much in a patent case as in any other case. The court is here to comply with the legitimate demands and requirements of the parties to resolve live disputes. It is not in a normal case here to resolve disputes that may or may not arise or may already have arisen in other jurisdictions. The overriding objective makes it perfectly clear to deal with the case justly, including so far as practical, saving expense, dealing with the case in ways that are proportionate, allotting an appropriate share of the court's resources, while taking into account the need to allot resources to other cases. If I were to accede to Mr. Tappin's submissions and go on in detail into the question of the whys and wherefores or the invalidity of the patent, I would be using court time that could otherwise be used by court users who are unfortunately queuing up to find time to bring their cases before the court. Now, bear in mind, of course, my own friend is saying between now and the 12th of December, he wishes to have a technical trial, the scope of which I'll come back to in a moment. That is therefore a case in which a patentee wished to maintain a case so that it had the benefit of a finding of the court for foreign litigation purposes, and it was not allowed court time to do so. This was not on the basis it was an abuse, but it was nonetheless something the court should not countenance. A case which is close to the present facts is a decision of Justice Mead in Edwards, Life Sciences and Merrill, has some similarities. The defendant alleged infringer wished to give up its defence and submit to relief, including injunctive ancillary relief, but did not wish to submit to a declaration of infringement or make equivalent express acknowledgement. It appears from the report there were proceedings elsewhere, and paras 17 and 18 make it clear that the parties were concerned about the presentation of matter abroad, including to a foreign court. Paragraph 28, the judge determined, in my view, therefore, that case, Fresenius, supports the submission. I'm not constrained to have to consider the question of whether or not there should be a declaration if I don't think it's appropriate use of the court's resources. Mr. Justice Mead turned to the use of judgment in foreign proceedings and says the fourth reason why a declaration is important for Edwards is for its possibility and utility in other jurisdictions. No concrete evidence, but that wouldn't stop me taking account of it, he says. Then he says, last 6 lines, but the current situation is rather different from that, because whatever step is taken from me here, the court in another jurisdiction will be aware that Merrill's attitude is they gave up for pragmatic reasons any trial that were undertaken as Edwards seeks would have been opposed by Merrill. I'm not persuaded that either a judgment made because Merrill under it would say coercion, gives an admission or a judgment made after consideration of the merits, when Merrill is not present, will have any material weight in any foreign jurisdictions. It's established on the authority it's entirely proper for a patentee to bring proceedings in the UK to want to get a decision which be considered in another jurisdiction. That's not the same thing as saying the court should go ahead and give an inappropriate amount of resources to litigation here simply so that can happen. In the remainder of his judgment, he considers the amount of court resources that would be required to go forward to a trial where a declaration would not be merited. In paragraph 43, he concluded, I ought to say in reaching this conclusion, I've already in mind that the amount of court time sought by Edwards is really very substantial. I accept the submission made by Edwards' behalf that it is a lot less than if all the trials had gone ahead, but nonetheless 1 day's reading, 2 days in court and judgment writing time is a lot of time to ask for the making of a declaration without the attendance of the other side, and which would probably not be of practical as opposed to presentational importance. That's been an important part of my thinking. It's right to observe that it was an important part of Mr. Justice Mead's reasoning that the declaration sought would be of less weight because the grant would have been unopposed, which suggests it might have affected his decision if he thought a decision would have had more weight abroad, but nonetheless he still applied a consideration of the court's resources. He comes to reviewing the authorities, and perhaps pick it up halfway through 75 for time. Although I cannot ignore Draxelmeyer's evidence on the point, such as it is, I give it little weight. The reality, I find it to be, is the real motivation was for use in foreign proceedings. That distinguishes this case from all the reported cases were cases in which there was a genuine domestic interest in the issues raised, whether infringement or revocation, at least at the outset of those proceedings. The remarks of Mr. Justice Arnold and Mr. Justice Henry Carr have to be read in that context. And that's the point I was seeking to make at the beginning, that there was a genuine domestic interest as opposed to being solely for export.
What about those words, at least at the outset of those proceedings?
Certainly, but then he comes, that situation can change.
Yeah.
And
well, hasn't that, there was a genuine UK interest at the outset of the proceedings.
Yes, but that's when there was no designation of there had not been the failure to designate the UK patent. But in fact, if one reads on, one actually sees that he's prepared to say it's an abuse from the outset.
Mm-hmm.
And for the authorities, he draws the following points. At E, I accept that TNS became a case in which the use in foreign proceedings became the justification for continuing proceedings, which apparently lost their original justifications. It was, however, a validity case in which Justice Arnold came to the view the claimant's desire to have commercial certainty of validity justified the continuance of proceedings, and there was no abuse. It doesn't follow in all cases, in infringement-only cases, a desire to have an English decision to present to a foreign court addressing the same issues is necessarily non-abusive. He cites Mr. Justice Henry Carr and Abbey, Mr. Justice Voss and Lord Justice Floyd, all expressed views which were contrary to allowing proceedings to be brought or continued in this jurisdiction, where they were academic here and smacked of forum shopping. In the light of these views, I consider I'm not bound by Mr. Justice Arnold's broad statements to hold an infringement claim or counterpart can be brought in this jurisdiction solely or essentially for the purpose being used to influence a foreign court. I prefer the view summarised in paragraph 76G of this judgment, and such proceedings could and should be struck out as an abuse, or at the very least stayed on case management. And then he applies those principles at the end of 82 on 423. Prolongation of this action beyond the surrender offer has been motivated by a desire to keep them alive, not only for the purpose of getting a useful judgment here, but for the purpose of getting a judgment that thought would be useful in German proceedings. That is not a legitimate purpose in these proceedings. So a useful purpose in Germany is not a useful purpose in the UK proceedings. From that point, therefore, at the latest, it was apparent these proceedings were not such to justify devotion of court resources, and they ought to have been brought to an end there. That leaves the question, the same applies to the preceding period. Logically, it does. I consider on the facts the real motive was the same all along, and the proper approach to this matter requires it be acknowledged. Even though Draxelmeyer technically had a claim, it proposed to do something relevant in this jurisdiction. In truth, this action was not about any such thing. And I submit that's the same here. In truth, when the patent was not going to be de-designated, everything came in that 23A paragraph in the re-amended particulars of claim. And in truth, there never was any confusion. On the judge's findings, there was no relevant UK confusion because Novartis wrote to the NHS England and said, look, the market's generic. There's no problem with getting fingolimod. Teva have got their established supply chain. There never was any confusion. really the only outstanding thing that was left was the fact that they essentially wanted the judgment to export to country A. Now, going back to Takeda, the judge notes Takeda was a decision. Or can I just break off for a minute and make one or two observations about Mr. Justice Mead's statement about basically the court would know this wasn't, the foreign court would know this wasn't a contested decision, because it's common knowledge that Novartis is not going to turn up, they're not going to present any experts of their own, not going to present any argument. So it's going to, there's two options. Either the Teva present a very full case, rather like an ex parte in which every point taken against them is made, or it's completely a one-sided story. And one thinks that it's probably going to go to a one-sided story because my friend says it can all be done on paper or in half a day. Well, when we come to see what happened in Italy, and I know my own friend objects to this, we'll look at it in a second for what it's worth. The fact of the matter is that there's an awful lot here that cannot properly be done on paper or in half a day when one sees the actual issues that are involved. And this was a case that was down, I think, for 6 to 8 days when it was contested. So that can only be condensed to a half a day, assuming that's not very much. But don't forget, the judge has got to write a judgment. They want reasons, so they want the judge to unpick the expert reports and give the reasons as to why it's done. And my own friend says, well, it's just a day in court, maybe, but not, that's all bootstraps. Yes, it may be half a day in court, but we've had all the days that we've spent coming to this point, arguing the error declaration, all the time spent on the evidence, on the amendment, on Wolters-Hörner that we'll look at in a minute. So, and this would apply in every case. You sort of get to this, get this far and say, well, we've come so far, there's only a small incremental amount of cost. But you've got to look at the whole block as to what this is involved. And it's days and days, and it's manifestly just for the purpose of Germany. The argument would apply to all cases. You could bootstrap yourself in pretty much all these cases by saying, well, it's not very long. Now, the next point, which is an important point, is that the English Patents Court has no special position in the hierarchy of competence of EPC states, has no greater competence or insight than any other EPC court, or any jurisdiction is strictly limited to the UK. The high water mark of Teva's evidence was that this would be of interest to the German court. And it's actually, that's the evidence that the judge summarises in paragraph 60 of her judgment. I don't need to go back to it. But I think, since my learned friend showed, my lords, the evidence of Dr. Wolters-Hörner, I should just do so briefly. It's SB Supplemental Bundle Tab 8. And at 4.5, paragraph 31 is the quote from the German Copaxone decision, I think, where Lord Mr. Justice Arnold heard 12 expert witnesses, I think, in total. It was a long trial. I think it was about 2 weeks. It was all to do with certain ratios of amino acids in a drug. And the 31, the German court said, based on this line of argument, the Chamber already found itself unable to make the assessment that the High Court's conclusion, which was arrived at after extensive oral hearing, with cross-examinations with experts, was carefully substantiated in view of all the arguments that have now been put forward, was evidently wrong. So they noted there had been extensive argumentation, extensive oral hearing, cross-examination. It did seem that it hadn't been pointed out at this time that it wasn't the case in this case. There was going to be such. And therefore, at 4.7, the expert, Dr. Wolters-Hörner, said, therefore, a reasoned UK court's judgment, given on the basis of an extensive oral hearing with technical experts and cross-examination, can be of particular relevance for the formation of the opinion of the German infringement court. Well, it was then pointed out there's not going to be that happening in these proceedings. And she was then given a different brief, which is in the next tab, at tab 9. said at 1.4, I've now been told that Novartis have said they won't be cross-examining Teva's experts and will not be engaging with technical arguments. I've been told in these circumstances the court will consider the expert reports that have been relied on by Teva and his submissions from Teva. It will be in light of those submissions reach a reasoned decision as to whether in a case of obviousness so the prior has been made out. I have been asked, and I asked the court to look at the words specifically that have been chosen here. I have been asked whether in these circumstances a decision of the UK court would be of interest to the German court in determining the question whether it's high likelihood to be invalid. My opinion is it would. Well, you have to contrast being of interest to the wording of her previous language, which was of particular relevance to the formation of their opinion. It's not a small change. Lawyers choose their words carefully. And in those circumstances, the highest that it could be put, there would be some interest, which really is not terribly persuasive in my respectful opinion. But that gives the background to paragraph 60 of the judge's judgment. Now, the court will be aware there's no unified procedure rules under the EPC for national enforcement. National courts are left to get on with it as they see fit. And here, this is simply a species of forum shopping. Teva chose to establish their hub in country A, and doubtless for other reasons it's advantageous to do so in country A. And what it's seeking to do now is to avoid the consequences of deciding to put a centralised hub in a bifurcated proceeding country where those two things happen. But in this case, the reality is extensive technical submissions have been made, and Teva have filed an expert report from a clinical pharmacologist called Dr. Adam Cohen. So each time my learned friend was saying there'd been no expert evidence in Germany, that's not right, because the German court has to consider whether there's a non-negligible prospect the patent will be invalidated. It can only do that if it assesses the technical evidence before it. So it's not just a American cyanamid arguable case approach. They actually look at the merits and do so on evidence. Now, I can illustrate that from the personal experience in Takeda and Roche, which was cited in the Draxelmeier case, where Mr. Justice Henry Carr acceded to the invitation to have the case heard before the long vacation in July, so that it could be on the table and be considered as well by the German court in Düsseldorf. And there was a full trial. Mr. Justice Burse, as he then was able to deliver his judgment on the 17th of July, 2019, finding the patent suit invalid, both for lack of novelty and want of inventive step on aggrevo grounds. And we've sidelined his judgment, for what it's worth, at JA 11. We don't need to go to it. And the German infringement court was asked by Takeda to say, look, Mr. Justice Burse is invalidated on the basis of lack of novelty and lack of inventive step. And the Düsseldorf Landesgerichtshof's judgment is at bundle JA tab 12. And we've only certified a translation of certain extracts. And at 201, it was said NIC 14 has been examined by the opposition division, was not considered to be prejudicial to novelty. In this respect, the EPO did not consider the LCMS polypeptide mapping disclosed. The citation was therefore rightly not pursued in the appeal proceedings. The English judgment obviously applies a different measure of novelty, which is not applicable here. So they weren't. The Düsseldorf court did not think that the UK court applied the same approach to novelty as the EPO. At 203, it said even if the person skilled in the art had cause from citation NIC 13, as the EPO rightly stated, as well as something else which had not been introduced to the EPO to increase the fucose content, because the link of fucose was apparent, it was not apparent, as the EPO decision also rightly states, what means the person skilled in the art could be used reliably to obtain a fucosylation level of 99%. Thus, the board cannot see where the solution is to be found in solid citation. In the rejoinder, the defendants named 4 ways. The board cannot easily verify this in particular, not in such an obvious and clear manner as would be necessary in the board's opinion to justify a decision to stay the proceedings based on lack of inventive step instead of a decision on the validity of the patent. And then, if one picks it up at 211, they say the fact that the hearing of an expert led the English court to the conclusion the patent in suit did not make a technical contribution to progress did not itself constitute a circumstance that would render the EPO decision manifestly incorrect. At most, there are two conflicting decisions on this point with regards to inventive step, and in this situation, the board cannot predict with sufficient certainty which result the Federal Patent Court will reach. So basically it said, thank you, Mr. Justice Burse, that's all very interesting. The EPO come to a different view, and we're not in a position to judge which is going to be the right view. But also what becomes apparent from the length of the consideration is there is extensive technical consideration, and there were technical reports in that case before the German court. Now in this case, there are even more decisions coming from France, coming from Spain, coming from the Netherlands, coming from Germany. And to take Italy as an example, we have at JA 13, sideline.
This is the judgment where we are objecting to. It wasn't before the judge, and it's not, as we understand it, being put forward as a decision of law. It seems to be a question of fact.
Is it your submission this court can't have regard to a decision rendered by a court in another EPC contracting state? Because if that is your position, one wonders why the German courts should take any notice of an English decision.
Well, my lord, is the question what was before the judge. That was my only
Well, of course.
Obviously, and this wasn't before the judge.
Of course. No, we obviously need to take that into account.
Well, my lord, I probably can't take it any further.
Very good, thank you.
If the court would go to page 381, the decision was issued in Milan on the 25th of October, which was about a week after the judge gave her judgment. So we couldn't have put it before the judge, or we would have done. Just taking the examples that we do, could I ask the court to go to 3.6? This was a PI case, but it just shows that the Milan court has a different approach to the merits. And then the relief and the background is set out in 368. And then I come to 370. Paragraph 2, the court considered must examine the issues raised by the parties following the criteria laid down by the law, and in particular the principle according to which the burden of proving the lack of patentability is borne by a party challenging its validity, even when, and typically in PI proceedings, the invalidity is raised as an exception. So there was a burden to show on the party challenging the validity that there was an issue of invalidity. Then the issues substantially involved the assessment of the validity of 894 are limited in essence to the alleged lack of plausibility of the elements set out in the description in order to support the effective achievement of the invention's effects, and the absence of inventive step related to the indication on the part of the patentee of the studies that would have concerned the specific dosage of fingolimod that is the subject of the patent itself. My learned friend rightly mentioned there's a publication that there were going to be clinical studies of 0.5 per oral of fingolimod, but there were no results from those studies. So did that make the claim subject matter obvious, even though you published the dosing regime that's going to be used in the next clinical study? And there's a lot of EPO authority on that.
Why isn't it deprive it of novelty?
Because as Arnold has pointed out, the attainment of the clinical effect is a functional limiting feature of the claim. And then paragraph 3, with regard to the first question, plausibility of the treatment of RRMS through administration of fingolimod at a daily dose of 0.5, the CTA correctly put forward a general framework of the EPO's interpretation. There was an independently appointed, court-appointed technical assistant, an independent expert who's appointed by the court itself to undertake an assessment, which was duly done in this case. According to the achieved technical treatment of the disease is considered a characterising part of the claim, and that's G2 of 88, that's the attainment of the clinical effect point. And then perhaps just for time I can move on to 373. Before, the other main profile objection to the validity of 894 is focused on the inventive step, also taking into account preliminary decisions in the Netherlands and France, which at first found possible elements in favour of invalidity of the patent under this profile. So there are judgments going both ways at the interlocutory stage in both the Netherlands and France. We never shirk from that. In this respect, the CTA found the closest prior art as the combination of documents consisted of Novartis' presentation of June 2005 and Novartis' press release, insofar as they come from the same source, are complementary to the same phase 3 clinical trials, with the 0.5 dose of fingolimod, even though they don't disclose the same information with respect to which the technical problem of the patent is intended to solve, made explicit in the patent, i.e. it works, can be considered as essentially identifiable in providing a treatment for RRMS that is at least effective as the closest prior art. That would mean providing a treatment which reliably achieves an approximately 50% reduction of the annual relapse rate and takes into account, according to normal consideration inventive step, in the evaluation of adverse effects of the content of the dosage study. It then goes on to review the documentation, and then if I could ask the court to go on to 377, and I think I don't need to get too much into the weeds of this, but basically the evidence was that a skilled person would have expected a certain amount of lymphocyte suppression to be needed, and all that had been published about this drug had suggested or shown that 0.5 would not be enough to achieve the relevant level of lymphocyte suppression. So basically the skilled person would not think it would work, and that was the finding of the Board of Appeal. If one then goes to page 378, again I'm just giving the court a flavour of this, the values of 38 and 44% cited by Thompson, this is halfway down, refer to an effective single extemporaneous dose, so on and so forth, and then it goes on, and really...
So, Mr. Wall, what do we get out of this?
What one gets out of it is you have had a court-appointed technical expert who many people think is more objective than the parties' experts after a selection process by the parties. And it comes, the punchline actually is in paragraph 5 on page 379, that in the light of the above arguments, as well as being from a technical and legal discussion that was specifically developed through specifically dedicated hearings, the court must conclude there's no concrete evidence of the respondent's objections regarding the alleged validity requirements. So the Italian court has gone through multiple hearings. It has the input of a court-appointed expert. And what does the German court do? Are we supposed to put into the balance a truncated UK decision, which Novartis hasn't actually fought? The reality is the German court can only come to its own views on the material before it. And yes, these judgments may be of interest to the German court. Let's assume that this Italian judgment is of the same interest to the German court as the UK judgment. What has the UK judgment added? In fact, it hasn't added anything material because, frankly, it's not one where there's been extensive cross-examination and argumentation, as happened in Copaxone. All that Professor Walters-Hörner could say about it would be of some interest. So, really, what this UK court is being asked to do is to spend its time trying to add a little bit more material to the German proceedings, which have no direct pertinence to a UK-orientated issue, in order to seek to bolster its position. And that, if there was no point before, there's even less point now, because it simply cannot say that this is going to influence the German court one way or the other. If I was sitting as a German judge, I'd say, well, I get a lot more out of the court-appointed expert, unless this has come back to my point, that the UK judge is not even being asked to go through this sort of exercise. It just isn't. It can't on paper in half a day, as my own friend submits. So you're basically wanting to generate an inadequate decision to try and counterbalance what is clearly, we would say, a very fulsome and adequate decision. So that's the point. I hope I've explained why I submit it's relevant. With no hierarchy of precedent, you're just putting something more into the washing machine. If it were the case that there was a one-way street, that this judgment from the UK, after extensive argumentation, might have some pertinence, then you could start to argue whether it would serve a useful purpose at all. But on the factual premise of it, with no hierarchy of precedent, then there isn't. And that's why I showed the court Takeda, whereby the UK court actually did have full argumentation, had extensive cross-examination, and the Düsseldorf court said, well, that's all very well and dandy, but what we've got are two conflicting decisions. We've got to make our own mind up. So it's not leading anywhere in this case anyway. Grounds of appeal. That's all I had to say on case law. The judge applied the wrong test. I think I've essentially made my submissions through the course of my submissions. This is the argument that in paragraph 61, the learned judge set the bar wrongly. And this is their main objection to the judgment. And in our respect for Ms. Commission, A, she didn't. We say the caution that is to be expressed is actually like Barrington Rock through the authority. And there does have to be some other compelling reason, if there is to be one at all. And the justification for that is absolutely clear. In our submission, what the judge said is an entirely correct appraisal, because FSA and Rourke, my learned friend seeks to say, well, look, the learned judge got it wrong because FSA and Rourke sets down much less limiting criteria for a declaration like this. But FSA and Rourke was considered by my Lord Justice Floyd in Fujifilm. It was considered in Pfizer. It's been considered by Mr. Justice Henry Carr. It's the starting point for all their decisions on this useful purpose. It is necessarily incorporated in each of those judgments. And to say that the judge basically should go back to FSA and Rourke without regard to what was said subsequently in Pfizer and Roche in the two Fujifilm cases would be clearly wrong. She didn't substitute the useful purpose for what she said in para 61. That was said specifically in the context of whether there would be a useful purpose based on the case law that she had reviewed at the start of the judgment, which I've been over and I don't propose to do so again. The judge did rely upon that as part of her investigation of whether there was a useful purpose. But she was fully entitled to do that. And indeed, we say it's an accurate statement of the law, and it's actually underlined by the discussion in Draxelmeier as to why the UK court should not be issuing these advisory opinions. Just because they'd served the party a commercially useful purpose, even assuming that was the case, it's not what this court should be doing. We say the judge made no error of law. Then there's the fact the judge failed to take sufficient account of the disruption of Teva's supply chain. This is their second string to their bow. But this is entirely circular because it stems really out of the effect on any foreign court. And in those circumstances, unless you can actually persuade the court that it is of interest or sufficient interest in order to send a judgment of this court to the foreign court, then the supply chain argument doesn't get off the ground. It was a very different supply chain argument that was being run in Fujifilm. And the Teva submissions raised the very same points we've discussed already in relation to spin-off value in country A and can be dismissed for the same reasons. Now, I don't think I need to submit further. That would be repetitive, so I won't. Right, remaining reasons. I was just going to explain how very different Fujifilm was to this case, but I think my lords have heard enough of that already. Remaining reasons. They say that the judge failed to give sufficient weight to the various facts which he considered when exercising her discretion, which were listed in A to E. And I think actually it's useful to see the way the judge approached it. If the court would take out the judgment. And it's page 63, tab 9. And the way that it was run was that Teva, this is in paragraph 34, Teva advanced essentially 5 reasons why in his submission a declaration should be granted. The first was Novartis' aggressive enforcement, including the fact that it had obtained adjunctive relief. Now, pausing there for a moment, the judge had some difficulty with this because she didn't know whether this was being run as a standalone useful reason or just some reason to exercise some sort of sanction. And that is actually, if the court would just drop down to 36 and 37, regarding the question of whether the declaration is sought in the context of dispute, Mr. Justice made it right. Sorry, but over the page, paragraph 42 and 43, Novartis' enforcement of 894. Teva's first reason turns on Novartis' conduct, including the fact Novartis initially sought to enforce its patent to the point of seeking interim relief before ultimately abandoning his patent. And indeed, Dr. Turner made the same opening to the judge that he made to this court this morning. While Dr. Turner initially suggested Novartis' conduct should be regarded as a standalone reason supporting the granted declaration, irrespective of this question of whether the declaration would serve a useful purpose, ultimately his position was this was a relevant factor. I consider that to be the right approach. There's no suggestion in the case law that even when a declaration would serve no useful purpose, a court might nevertheless grant a declaration to censure the conduct of the defendant and to discourage such conduct in the future. And what the judge then did is that, well, he looked at whether it added anything to the other reasons. At 49, she says Novartis' conduct doesn't change that position, and she comes back to that also, I think, in paragraph 70. She does come back to it. But the fact of the matter is, it's not a standalone reason. And it only became necessary in this case because the patent was granted, the notification of the fact it would be granted was made at the hearing in February. And the EPO didn't get round to actually granting the patent, I think, until October. So, basically you had this right languishing, and it doesn't make any difference, or shouldn't make any difference in principle, whether the patent's a granted patent or a pending application to this particular argument. But going back to paragraph 34, then the second head was that the declaration would provide clarity to Teva's customer in the UK. That obviously was a big issue. Then there was the inadequacy of Novartis' undertakings in dispelling uncertainty in the UK market. Fourth, potential utility of judgment into Germany. And fifth, the fact that Teva's supplies transit through country A, such an injunction against Teva would threaten that supply chain. Now, the judge on the evidence found there was nothing in 2, there was no uncertainty. On the evidence, there was nothing in 3. Therefore, it came down standalone to 4, and the interrelated issue 5. And Monofriend makes much of the order in which the judge deals with these things, but nevertheless, it doesn't actually detract from the fact that she correctly decided it added nothing to the arguments existed on. So the order of the consideration actually makes absolutely not a row of beans difference to the outcome. So there's nothing in that. Insofar as Novartis are held accountable in terms of the obtaining the injunction, just going back to that, they are in terms of costs, that's already been gone through. They are in terms of the cross-undertaking, which is open to the defendants. And exerting the application in the UK has become a significant cost to Novartis. And if my learned friend's argument on this was taken to its logical conclusion, then whenever a party is sued on a patent and sought to enforce it, that party could never discontinue or withdraw without being liable for declaratory relief. They say, you started it. You can't get out of it without actually giving the declaration that we've sought. Becomes another bootstraps, we say self-serving argument. The fact of the matter is there's just no nexus between Novartis' conduct and the need for an arrow declaration. Reminiscent of Mr. Justice Woodford saying to Mr. Anthony Watson of counsel, Mr. Watson, that's pure prejudice, isn't it? And Mr. Watson says, well, I do hope so. Anyway, in conclusion, therefore, the appeal is no more than a request to revisit the judge's findings on discretion when no relevant error has been found. Even if the judge did pitch the hurdle too high or too differently, it makes no difference to the actual policy behind not having judgments written purely for advisory purposes abroad, for the reasons that Mr. Justice Voss explained in the Fresenius case and imported by Sir Anthony Mann in the Drexelmeier case. So, unless there's any questions, those are my submissions.
Thank you.
We are normally in these proceedings at trial. We are in these proceedings at trial. We are hearing the question of discretion and the assumption that we have succeeded in showing that the subject matter of the patent is obvious. This is under circumstances where the patent has been enforced against us and where the court was told it will certainly grant. Today, and other cases may be different, but today no question of proportionality or abuse arises. not only because of the stage of the proceedings we're at, but because that's simply not the point that has been argued below. Mr. Waugh accepts, or at least accepted at one point, that there's no hard-edged rule which precludes the court from exercising discretion in our favour where the useful purpose was for use overseas. So he doesn't take issue with Mr. Justice Burse's finding in that case. There's also no dispute that this is commercially important. Standing back then, what is the reason? Obviously this is a rhetorical question. What is the reason for not granting a declaration if we have succeeded in trial? What is not just in refusing to grant the relief that we have properly sought, we say, from the court? Now, part of the concern is that in many cases, and the Court of Appeal have given their Romania example, it may not be appropriate, you're in the wrong forum. But in those cases, actions, as I've submitted earlier, may be stopped as not proportionate, or indeed that may, in certain circumstances, be a special reason if it has no connection, really has never had a connection with this jurisdiction. My learned friend says, well, look, this will apply in every case. This is a sort of chart now, irrespective of whether it's a granted patent or a non-granted patent, an application. But that is not right in our submission. What normally happens is if you want to get out of a piece of litigation and there is a counterclaim, you submit to judgment on the counterclaim. And that's what my learned friend is refusing to do in this case. And he wants to stop these proceedings without submitting to judgment on the counterclaim and without making submissions that the action is not proportionate and should be struck out for that reason. We have looked at Pfizer and Fujifilm, and we have to distinguish the principles that are identified in that case from the exercise of discretions. And at times I felt my learned friend was really relying on the way the discretion was exercised rather than the principles that we get out of those cases. But both those cases are to be distinguished in a material way, in that in neither case was there an allegation of infringement in the UK and the attempt by the defendant to engage the jurisdiction of this court. In Fujifilm, Mr. Justice Henry Carr relied upon supply chain arguments as a factor. It wasn't the only factor, but it was a factor in his decision to grant a declaration. And in Pfizer, Mr. Justice Burse was not persuaded that that was sufficient. And I've made submissions as to why that may be, and in particular I've drawn attention to the timing, the references to the fact this can all be decided in Belgium. But he was not persuaded, and that was a factor on discretion. But of course, that is, neither case suggests that this was not a relevant, useful purpose. So the fact that it's going to have an impact on supply chain satisfies the, in my submission, useful purpose test. And then the court, of course, needs to go on to special factors. The passage at paragraph 88 of Pfizer, just at the last sentence, it says sorry, I'm just going to misquote it if I don't turn it up. Mr. Justice Burse says that the court will look carefully at a case in which the only or predominant purpose of the declaration sought is to use the court's judgment in foreign jurisdictions, and we accept that the court will look carefully at that. What Mr. Justice Burse was not saying, and taking that statement in context, was not saying but it cannot be a useful purpose. But saying it is a factor that will require be part of the considerations. And as my lords have heard from our submissions, we say that the judge in this case, her ladyship, went further and did apply it as essentially a shifting the burden case will only be granted in where there's a very compelling justification for doing so. And my learned friend is really saying very compelling justification. I don't think he really sort of came up with a case in this area where you would ever have a compelling justification. I think it was the sort of never say never. But effectively, he's saying that that's a rule of law, rule of practice. So certainly one can look at the jurisdictional aspects from the perspective of a special reason, but we say when one gets onto special reasons in this case, they favour a grant of a declaration. And again, risk of repeating, but hopefully for the last time, we say it is the defendant has engaged the jurisdiction of this court and refused to submit to judgment on the counterclaim. They have misrepresented to this court that their patent would grant. I'm not suggesting that there was any insincerity when those words were stated to the court. But it wasn't an unexpected act which led to that patent not granted. It wasn't something out of their control. They deliberately withdrew it. They are the intervening act. And then they refused to come to this court and explain, or come before her ladyship and explain. And as I say, refused to submit to judgment. And having failed to get an injunction before Mrs. Justice Roth, they now want to stop supply coming to the UK by seeking injunctions elsewhere, and by going to the country A to get an injunction, they are achieving the same effect by the back door. And we say that is highly unsatisfactory. And that is a reason, a particular reason. There is a useful purpose, we say, and that's a particular special reason as to why the declaration should be made in this case, given the jurisdiction. My Lord Justice Nugee asked a question about what will happen in Germany, which I'm not sure I answered properly. I think what's happening in Germany is that there will be, there's now an opposition process starts. So it starts on grant of the patents, and then there's a 9-month period during which oppositions, that's called the opposition period during
To be clear, you're talking about the EPO.
The EPO, I beg your pardon, my lord, yes. So after grant, there's a 9-month period at the European Patent Office when an opposition can be filed. There's then an opposition, and then there's an appeal from that. And this takes many, many years, 3 to 6 years, sort of thing. We're talking about 3 to 5 years. And in Germany, they won't rule on validity until the end of that process. So there's no final determination of validity of the proceedings until the opposition process has completed. And so then one has this, which we've looked at the evidence, we have this application for a preliminary injunction. The German court won't have evidence. I'm going to come back to that point because my learned friend disagreed. And what will happen is, of course, my learned friend now wants to put before the German court the Italian case he's now just referred to, but wants to stop us putting a reasoned decision of this court. As to whether or not the German court, we didn't understand this was in dispute at all, the fact that the German court will not have technical evidence before it. And if I can just, again, it's not been disputed, and I think it gets picked up in the judgment, but remind my Lords, of the passage we looked at in the evidence in the core bundle, supplemental bundle, beg your pardon. It's tab 8. And 4.2, a German court, when deciding whether or not to stay the infringement proceeding when considering an application for a preliminary injunction, does not hear a technical expert. A preliminary injunction is procedurally not possible to have formal evidence, e.g. appointing an independent technical expert for these proceedings is supposed to be quick. And that gets picked up in 4.4 as well. However, the German infringement court will consider the prior art and decisions of the EPO and the courts from EPC contracting states. And that wasn't disputed by my learned friend's expert. And that underlies, there's a finding of the learned judge as well, which is at 56 of the judgment under appeal, and 56.2. German courts, considering patent infringement, rarely consult independent experts. So that's just recording what was we understood to be common ground. Of course, we accept that just because this decision gets shown to the German court, this decision, if it is made, gets shown to the German court, doesn't mean the German court will necessarily find in our favour. We've never gone that far, but just as my learned friend will be deploying the Italian case, we do see a particularly important role at these stages of the proceedings in Germany, because they can't consider validity fully at that stage, to have a reasoned decision of this court. My learned friend says, well, it's going to be, paraphrasing him, a bit of a rubbish decision, because I'm not taking part in it, he says. My lords, we don't agree with that, but that's sort of rather taking the ball away. He seems to think that's a point in his favour, that he's refusing to play a part in it, and consequently it will be of less value. We certainly don't accept that. So its choice to deploy this recent Italian case as, of course, part of its pan-European strategy works very well, and part of that pan-European strategy is spending a number of days arguing why it should not submit to judgment on the counterclaim in this case. My lords, I wanted to go to the Druckelmeier case, which is at tab 15, I think. I'll just pick up a couple of points that I want expressly shown to you. There's no criticism, my learned friend, but just for completeness. So paragraph 54, I think my learned friend went to, and just at the bottom towards the bottom of paragraph 54, the learned judge talks about the validity gap, the injunction gap. One of the potential uses of an English decision on validity, which has been identified as a legitimate use, is in addressing the injunction gap which arises in jurisdictions like Germany, which offer a bifurcated system. So that's the point my Lord versus Nugee. I was trying to explain that the Germans will not be considering validity until much later. They do infringement and validity separate. And in which the foreign court has to address whether to grant an injunction having found infringement pending a second trial of validity issues. Apparently English decisions on validity have a part to play there. That does not apply to English decisions on infringement. So that distinction has been drawn, and one sees it also at 56. As a starting point, it would appear that in this case, Mr. Justice Mellor was less than convinced about the utility of the English decision on infringement as opposed to validity. You see that. Then I just wanted to pick it up as 68. That's Fresenius and Care Fusion. Justice Voss had to consider whether to order trial to consider the basis in which a patent failed in circumstances in which the patentee agreed the patent should be revoked. So we're going to submit revocation in that case. And one of our complaints here is they're not submitting to judgment in this case. And 69, we again say, he said the successful party got what he wanted. The patent was revoked, so there was an order for revocation. It's submitted to judgment on the claim. And then the decision at 69 is very much done on a proportionality basis. So referring to Mr. Justice Voss is concerned about what is proportionate, allotting the share of court's resources, and so forth. And these points were never made below. This is not the basis upon which one can, of course, envisage another case where the court says we can see the utility in using this in another jurisdiction, but we're not prepared to expend resources on that. Of course, that may well be another case, but that is not the basis of the decision below. And again, one sees that again at 71. I do not think that it's appropriate, right at the bottom of the citation, I do not think it was appropriate use of the court's resources. And then my Lord Justice Floyd picked up, at least at the outset of those proceedings in 75. And then at 76, we see this, the judge clearly was taking a different view on validity proceedings as opposed to infringement, and he picks that up again just at the passage at the bottom of 77. I prefer the view summarised at 76G of this judgment. Such proceedings could and should be struck out as an abuse, or at the very least stayed on case management grounds. I express no views as to whether that applies to validity claims to which the considerations may apply. My lords, there was a point about special reasons. So I've shown, my learned friend said there was some discussion about whether special reasons was a standalone issue before the judge. I was asked questions about that, and I did accept I prevaricated, and then I said no, when I relied on standalone, I accept all that, and it's recorded in the judgment. But the special reasons were pleaded. That's the behaviour of Novartis and the way the history of this case, which we say is very important. That certainly was pleaded, and it was also made good that was a special reason in all submissions. That's in page 52 of the transcript. I need to get the tab. Tab 15. Sorry, I wrote 51 down on a piece of paper. I'm not sure my own friend said otherwise, but one could see that submission being made in the passage there. My lords, I wasn't going to go back through the judgment. My learned friend spent very little time on the judgment, and I think my lords understand our argument why we say the learned judge is applying too rigid a test. Can I just take instructions if there's anything else? My lords, I can be of further assistance.
Thank you all for your submissions. We will rise and consider where we are going to go from here. So, having considered carefully the arguments of the parties, both in writing and orally, we have concluded that the appeal should be dismissed. Reasons for that decision will be given in writing later. That will be handed down remotely in the now conventional way. You will get a draft under embargo in the usual way to correct typographical errors and any obvious mistakes, but not to re-argue the case, obviously, because it will be too late by then. We would have thought that you would probably wish to see the reasons before you deal with consequential matters, and then you could deal with consequential matters in writing in the usual way. You may be able to agree them, if not to deal with them briefly in written submissions. But if for some reason you would rather deal with consequential matters here and now, we're willing to hear from you on that.
I think we'd rather see the reasons, my Lord, as well.
We agree on that.
Very good. In which case, that brings us to an end for today. Thank you again for your assistance. We will try and get our judgments out to you as soon as we can, but I'm afraid I'm making no promises as to precisely how quickly that will be.